All right, so what I want to do first is review Wisconsin sentencing law, and this will be quick. Wisconsin sentencing law has undergone a number of changes in the last 25 years. There's sort of terms that people still use, even though they seem like they would be out of date. Old law, some people who would remember this, but this is old law for offenses that were committed prior to 1984. You had statutory good time, they called it, and then you could earn extra good time in certain circumstances. That was changed in 1984 for offenses committed after June 1st, 1984. The change was referred to, and I think still is pretty much referred to as new law, and that changed a little bit in terms of it getting rid of the extra good time, and the MR date was established at 2/3 of the sentence, which I don't think was a change from old law, but there were some fairly significant changes in that sentencing bill. And it was around that time, if you remember, that the truth in sentencing movement or determinative sentencing movement was really starting to gain favor nationally. And at the time, after into the early 90s, there were various reform proposals in various study committees and proposals for legislative change. Ultimately, it led to Wisconsin changing the law to go with determinative sentencing, truth in sentencing. In 1997, Wisconsin Act 283. I don't know if you remember, recall, or frankly have any interest, but at the time, Governor Thompson had appointed a task force on correctional sentencing that was chaired by Walter Dickey, and they came up with some very different recommendations having to do with a whole different type of sentencing in Wisconsin that would have transitioned people back into the community through sort of community confinement type sentences, and it was going to be a completely different direction for sentencing. The task force's recommendations ultimately gathered dust on some shelf, and instead Wisconsin went to determinative sentencing, bifurcated sentences. This is what most people are familiar with in terms of sentences now. You have a period of initial confinement followed by a period of extended supervision. There was no possibility in the original TIS 1 legislation for good behavior reductions. It was one of the big criticisms of, at the time, Senator Gary George and others in the legislature had with the new law, because obviously the incentive for good behavior on behalf of inmates was really taken away. And the goal of truth was strongly favored and really drove that legislation. The idea was that people were concerned that nobody knew how much time someone would actually get if they were sentenced to 20 years for sexual assault or for a homicide, and there were all the rumors, oh, people get 10 years and they're out in 6 months and all this kind of stuff. People were really concerned about whether there was transparency in the sentencing process, and the old indeterminate sentencing was really looked upon as being the source of that problem. So the goal of TIS 1 and ultimately reforms to some extent since then has been to make sure that people do the time they get. What you get is what you do, and to reduce opportunities for early release, for good behavior, or for in other programs. There was criticism because I think at the time TIS 1 was adopted, the idea was that there would also be sort of a rewriting of the criminal code so that a lot of the old mandatory minimums would go away, and a lot of the things that were driving longer sentences would be adjusted. Some of the crimes would be readjusted. And that's essentially what happened with the Criminal Penalty Study Committee, that ultimately recommended and came forward with TIS 2, Truth in Sentencing Part 2, for offenses committed after February 1st, 2003. TIS 2 redesigned the entire classification system for felonies in Wisconsin to what we have today. It realigned a lot of offenses and recategorized them, changed the penalties. Some of them actually became shorter for certain types of offenses. And they introduced the possibility of sentence adjustments under 973.195, which basically, frankly, I don't know if a lot of these have been granted. My guess is not a lot of them have been granted, but the idea was that depending on what type of crime you're in for, you could petition for a sentence adjustment at 75 or 85% of the sentence you're sentencing, or the length of your sentence. And I think a big flaw with the first truth in sentencing legislation in Wisconsin that maybe was anticipated, maybe not so much. I tend to think maybe not so much. I know that when this mechanism was created, some of the judges didn't really understand how it would work. I remember here in Milwaukee County there was what I'm talking about here is the reconfinement after revocation. So when you get revoked off ES, you go back to court, and I think some of the judges were thinking that that was going to be a fairly almost rubber stamp type process. But instead, what happened is they expanded into full-blown sentencing hearings. And of course, you know, it's a sentencing hearing that you have absolutely no way of prevailing in, right? Because what's going on here is you go back in front of the judge that sentenced you. You go back in front of the judge with a bunch of new violations because, of course, your ES has been revoked. So there's you probably have very few things that are great that are going on. And, you know, let's face it, the judges are sitting there. They're looking at a DOC memo, and then they got the DOC matrix that's recommending just very little time because the the revocation offense or the rule violation perhaps wasn't so great. But a lot of them were of course people who had been revoked for new offenses. And then of course you got the DAs in there, and they're just like, I can't. This person, he didn't do well on probation. He must have the maximum amount of reconfinement time. And the judges, they just that was like serving up a huge dessert for them. It's like, yes, maximum amount of reconfinement time. And so that was really started to drive the prison numbers, and I think that's one of the things that was primarily driving the uptick in prison numbers, is these people who are out on ES getting revoked and coming back in front of judges and just getting all kinds more time in addition to perhaps a new offense or whatever. So I think that was a real flaw in TIS 1, TIS 2 that brought us to some extent to the changes that we have under Governor Doyle in the Budget Act 2009 Wisconsin Act 28. So we've got a number of different changes that have happened in this, and basically what we're talking about is the Department of Corrections refers to it as TIS 3. Did they call it TIS 3 downstairs? Anybody was down there? No, they didn't. They call it that on their website, TIS 3. But it's really sort of not quite so TIS, because the truth of the truth in sentencing part might not be quite there, or quasi-TIS, because, again, there's a little bit less transparency under some of the changes we're going to be looking at. When what we're talking about is sort of cracks in the foundation of truth in sentencing, because what truth in sentencing is all about, again, is what you get is what you do, right? The judges say, you're going to be sentenced to prison for an initial confinement time that you serve day for day, and if you mess up, you can even do more time than that, right? And so victims knew, DAs knew, everybody knew exactly how much time people are going to do. But now, under Wisconsin Act 28, 2009 Act 28, there's going to be less transparency, arguably perhaps less truth, although I don't know if that's something we want to be shouting about. But there will be more opportunities, and I think this is important, more opportunities for clients to help themselves get out of prison early. It'll give them more incentive to behave well, and I think there will be some correctional programming that's supposed to be geared specifically, individualized for the types of problems that people have, and allow them opportunities to get out before their initial confinement time is complete.